The only reason that the district attorney himself wants that record sealed is to prevent public disclosure and access to the very record of his wrongdoing.
And nowhere in there did I hear any proof.
I am maintaining prior sanctions that the court has previously imposed. All right, the court will call 25 CR 298 and 25 CR 253, the people versus Nancy Ray Medina Coaches. Ms. Medina Coaches appears in custody from the El Paso County Jail via WebEx. Mr. Cutler and Mr. Lipka are appearing on her behalf. Ms. Turner is appearing on behalf of the people. We were set today in 25 CR 253 for a pretrial readiness conference and a pretrial conference in 25 CR 298. The court has a pending motion to dismiss before the court. Mr. Cutler, as to any additional argument regarding the objection to motion to dismiss.
Yes, Judge. This simply is a tactical decision to create delay. I haven't received or reviewed this objection. I did hear the court say that it's uploaded this, and Ms. Turner did notify me that the DA's office had received this package from Bacchus and Shanker yesterday. I asked her if she had called Bacchus and Shanker to confirm that this was a subpoena deuces taken production. She didn't have any contact with them or follow up on this in any way before refusing the delivery. But certainly it does appear that despite their objection, Bacchus and Shanker sent something. I don't know what it is. We believe this is mitigating and exculpatory evidence. The court has directed me to seek out the authenticity of that mitigating and exculpatory exhibit. Bacchus and Shanker was identified by the district attorney as the source of that information and exhibit. They have not responded. This subpoena was served at the end of May before the grand jury indictment was returned. I have the return of service if the court needs to see that. The problem with the dismissal, Judge, is related to the subpoena is that I don't want a curtailment of or delay of the proceedings in this case. At this point, we have a pending motion to dismiss the indictment in 26 CR 11. We are pending and set for trial in 25 CR 253 in September. The district attorney has produced no discovery since March 2026 in 25 CR 253. The reason that that's important, not only based on the pattern of Mr. Lindsey's conduct and management of discovery during the pendency of this case since 2023, is that a search warrant issued by Mr. Gravatt, DA investigator Ron Gravatt, March 2026. The results of that search warrant were produced by the district attorney in 26 CR 11 pursuant to this court's orders as their new evidence warranting the indictment in 26 CR 11. But to our ability, we have been scanning, scouring discovery. There has been no production of the search warrant results since March 2026 when Ron Gravatt's search warrant was issued by this court. What instead we have are products of the search apparently deemed beneficial by the district attorney's office used before the grand jury, which depicts a search or a successive search. I don't know how many searches the DA's office has done of an iPhone collected or iPhones collected from the Herbal Gardens Wellness Center's white Dodge pickup truck, inventoried and seized during the arrest of Miss Medina Coaches in New Mexico, November 21st, 2023. That discovery is absent. We cannot find a production of discovery since either before or in the same contemporaneous time frame as issuance of the search warrant. Mr. Gravatt has not otherwise produced, nor the district attorney, Mr. Lindsey, produced the discovery related to the search warrant results. The district attorney has noticed that we are concerned about the withholding of exculpatory and mitigating evidence, both under our SDT to Bacchus and Shanker, the litigation related to that since January. The district attorney has a pattern of behavior of late, dilatory, repetitive, or non-disclosure of material relevant evidence in this case, going back 3 years. I'm not going to belabor the court's findings of that, but certainly we seem to be susceptible to a continuing pattern no matter which case number I appear on in which day. The problem that I have, Judge, is that we can't stay on track to prepare for trial timely and within the timeframes of Ms. Medina Coches's constitutional right to speedy trial, given the district attorney's behavior and conduct. It is very simple to discover and disclose evidence. It is very simple to acknowledge and identify chains of custody for where that evidence is and what's happening to it in a criminal case. Nobody has better control, supervision, and possession of that evidence than the district attorney himself. And yet we seem to be here repeatedly, in this case specifically, routinely asking for discovery and timely disclosure. What instead we have are products of the search apparently deemed beneficial by the district attorney's office used before the grand jury, which depicts a search or a successive search. I don't know how many searches the DA's office has done of an iPhone collected or iPhones collected from the Herbal Gardens Wellness Center's white Dodge pickup truck, inventoried and seized during the arrest of Ms. Medina Coches in New Mexico, November 21st, 2023. That discovery is absent. We cannot find a production of discovery since either before or in the same contemporaneous time frame as issuance of the search warrant. Mr. Gravatt has not otherwise produced, nor the district attorney, Mr. Lindsey, produced the discovery related to the search warrant results. The district attorney has noticed that we are concerned about the withholding of exculpatory and mitigating evidence, both under our SDT to Bacchus and Shanker, the litigation related to that since January. The district attorney has a pattern of behavior of late, dilatory, repetitive, or non-disclosure of material relevant evidence in this case, going back 3 years. I'm not going to belabor the court's findings of that, but certainly we seem to be susceptible to a continuing pattern no matter which case number I appear on in which day. The problem that I have, Judge, is that we can't stay on track to prepare for trial timely and within the timeframes of Ms. Medina Coches's constitutional right to speedy trial, given the district attorney's behavior and conduct. It is very simple to discover and disclose evidence. It is very simple to acknowledge and identify chains of custody for where that evidence is and what's happening to it in a criminal case. Nobody has better control, supervision, and possession of that evidence than the district attorney himself. And yet we seem to be here repeatedly, in this case specifically, routinely asking for discovery and timely disclosure. The court has imposed sanctions in 23 CR 23, which were transferred to Fremont County 25 CR 253 previously. I want to ensure that those sanctions, if the 25 CR 253 and 25 CR 298 cases are dismissed, that those sanctions apply in 26 CR 11. I have very grave concerns. I know the court is still conducting its probable cause review of the transcripts from the grand jury. I have very grave concerns about whether there actually is new evidence, and DA Lindsey's representation that 26 CR 11, both to this court and to me personally, is reflected in the email I tendered after our last hearing, that 26 CR 11 is a new separate case. There's nothing from the exhibits produced to date indicating that it wasn't evidence held by the district attorney since November 2023, or that it's a new and separate case against Ms. Medina Coches, which has resulted in her incarceration. That incarceration, Judge, I have represented to the court, is cruel and unusual. We held a hearing in Custer County on July 7th, in which the court issued an order of medically necessary accommodation to Ms. Medina Cochis that has not been fulfilled by the El Paso County Detention Facility. She has not, for instance, been produced or provided the sunglasses that are in her property at the El Paso County Jail. As the court can see, she is not wearing a hat. She is not wearing sunglasses today. She has not been provided a liquid diet. She is being denied medical kite requests for medication and medical monitoring by the medical unit that is going to be subject to a follow-up subpoena to the jail for those medical records. They are not communicating with her primary care physician. They have a walker in Ms. Medina Cochis' property at the jail. She has not been provided a walker. We seem to be in a situation where whatever punishment this district attorney can find to apply against my client is being used to cause her adversity and create a situation where she is unable to assist in her own defense. These are hugely big issues that we seem to be brushing over in a whitewash effort to a do-over in 26 CR 11 from the deplorable record that exists in 25 CR 253, 23 CR 23, and 25 CR 298, Judge. I can't emphasize enough that we should not move forward quickly to dismiss this action until we know whether or not exculpatory mitigating evidence within the possession of Bacchus and Shanker, the district attorney, has been withheld from Ms. Medina Cochis, whether we know or not whether discovery has been withheld that should have been provided to her since March of this year. What I can tell the court is we haven't received a discovery packet since then, and it coincides with the date of Mr. Gravatt's search warrant. So we're once again showing up in court at an informational deficit, trying to explain the hardships created by the district attorney's actions and pattern of abuse of Colorado law, the rules of criminal procedure, specifically Rule 16, and his own rules of professional conduct governing the actions and behavior of the prosecutor. There's no justifiable basis for this, and it's a disgrace. It undermines the very interests of justice that this court sits to preserve and protect and provide to every citizen in the United States. Ms. Medina Cochis says her rights being trampled at this point, and I'm concerned that any premature dismissal of the Fremont County cases to then simply proceed on 26 CR 11 undermines the fact that it's not a new and separate case, undermines the fact that this is not a secret attempt to whitewash a record of the district attorney's wrongdoing, undermines the very things we have been litigating and preserving a record on. The motion to dismiss is not simply a motion to dismiss by the DA. It is a motion to seal the record in those cases. The only reason that the district attorney himself wants that record sealed is to prevent public disclosure and access to the very record of his wrongdoing since he took office in November 2024 and that of his predecessors on this case since Ms. Medina Cochis was arrested. Thank you.
Ms. Turner?
I'm just not sure. I didn't hear any legal authority. I heard the district attorney's office called deplorable, accused of secret scheming of whitewashing, secret scheming to deny public record and access. And nowhere in there did I hear any proof or evidence of such, but just to me, it's more like name calling. You know, and we heard about a lot of things such as whether or not El Paso County has followed through with the court's order to.
Well, Ms. Turner, with all due respect, I can see right now that the order is not being followed. I can see that.
Oh, I'm not suggesting the order isn't being followed.
Okay.
I don't know if it is or is not.
I mean, I can see it's not being followed.
Yeah, I don't know if
she was ordered to be
those
provided
things
a walker. She was ordered to be provided a sunglasses and a hat. And I am not seeing those items, at least at this point in time.
as far as the issues raised in regard to discovery, again, I haven't heard that legal authority. And certainly I'm aware of when the packets related to the search warrant were disclosed to the defense and they've been downloaded. But again, a lot of accusations, a lot of name calling, and a lot of issues that, quite frankly, are just not, in my opinion, legally tied to the people's motion. So I'd ask the court to allow the people to proceed in their prosecutorial discretion and grant the motions filed by the people. Thank you.
Ms. Turner, has discovery been disclosed in regards to a return and inventory as to the March 19th search warrant that was issued in 25 CR 253?
That was in Discovery Packet 3, right? Discovery Packet. Yeah, in the 2026 cases in Discovery Packet 3, it was downloaded by Mr. Cutler on June 16th and again on July 6th.
Is there a reason it wasn't disclosed in this case, considering the court had not ruled on a motion to dismiss in this case?
I don't know why it was disclosed in the other case, but it's in the possession of the defense.
So the court did look at both the case law cited in this case as well as the, quite frankly, because I think it's uniquely intertwined, the motion to dismiss filed in 26 CR 11 Custer County. I think the court is not finding that there is any sort of double jeopardy issue, given that jeopardy has not attached in either of the cases because a jury has not been sworn in either of the cases. I also, and I think there is some concession in the prosecution's response. I'm specifically looking at section 2 of the response, indicating that the prosecution is neither naive nor is scheming to think its current course of action would do such a thing and referring to whitewash the record of sanctions. The prosecution is aware of Rule 16 and case law that does not allow this court to ignore previous sanctions and be mindful of such in subsequent cases. So I am, and I will let the parties know, I am maintaining prior sanctions that the court has previously imposed and maintaining prior discovery violations found in these cases when considering discovery obligations and any issues with such obligations in Custer County Case 26 CR 11. I certainly could understand the concern of wanting records to be available, Mr. Cutler, and if there's an objection to the sealing of these cases, I am happy to hear that so that these cases are still a matter of public record. Before I issue my ruling as to the motion to dismiss, I do believe that any named victims have the right to be heard as to that motion to dismiss, and I know we have Ms. Emily Tofty Nesteval, and I'm so sorry if I butchered any of that name, as Ms. Patty Dalton's attorney appearing via WebEx. Ms. Tofty Nesteval, and I'm again sorry if I am butchering that. Is there any record that you wanted to make in regards to the motion to dismiss?
I am an advocate with the Rocky Mountain Victim Law Center, not the attorney.
Okay.
But I will say that our client, Patty Dalton, does agree with the district attorney on this.
Ms. Dalton, thank you. Ms. Dalton, you also have the right to address the court. I know you have an advocate here that has expressed your position, but you have the right still to address the court if you would like to do so, but you do not have to. Okay, all right. Thank you, Ms. Dalton. So I am going to grant the motion to dismiss. Like I said, I will issue an order regarding the SDT so that and finding that is essentially being litigated in that case going forward. And the reason I am maintaining in 26 CR 11 the prior sanctions as previously imposed and the prior discovery violations found is I am finding that the prejudice from those discovery violations is still present, given that there was concurrent overlapping prosecutions. I did, though, however, want to get a position, Mr. Cutler, in regards to sealing of these cases, if there is a request to not seal these cases.
There is a request, Judge. We objected timely to that or to the dismissal in an effort to seal. As the court's well aware, the public record replete with the very information, litigation records, minute orders that will be necessary, certainly for Ms. Medina Coaches, should any appeal be filed in the future. There is also clearly a public interest in the record of violation committed by Mr. Lindsey, perhaps necessary for future alternative litigation, both by co-defendants or other defendants in the 11th Judicial District, which I think warrants a public interest in not sealing the records from 253, Custer County 23 CR 23, and to any extent related, Fremont County 25 CR 298. I'd note that the district attorney's indictment with the grand jury's indictment tendered by the district attorney in 26 CR 11 has either incorporated or assumed the charges or escalated those charges that were pending in 25 CR 253 and 25 CR 298 currently in Fremont County, all of which date back to the November 20th, 23 incident in Custer County. So we do object to any sealing of the record of the dismissed matters 25 CR 253 to the extent that 25 CR 253 dismisses 23 CR 23, object to sealing that record, and 25 CR 298, Judge.
Ms. Turner, you looked like you wanted to make a record.
I just wanted to make a record since we had discussed Ms. Medina Coaches' accommodations at the El Paso County Sheriff's Office. When we were in Custer County, I told the court that we would forward the court's order to the El Paso County Sheriff's Office. I just want to make a record that we did that last week after the court issued the written order. That was forwarded to Under Sheriff Jeff Kramer at the El Paso County Sheriff's Office. So I believe we've met our obligations. I certainly, again, didn't have any intent of discussing whether or not they've followed through with those obligations. But I did want to make a record that we had forwarded that order.
I think the right to a sealing of a dismissed case rests with the defendant. I am in recognizing the defendant's right to sealing and potentially the benefits of, or potentially the needs for not sealing these cases, as well as 23 CR 23. I am not ordering for sealing at this time. The court will readdress sealing these cases if there is an automatic sealing right in 26 CR 11. In Custer County, but we'll go ahead and go off the record because those will be the orders of the court. This will vacate any future court dates as to these two cases.
Judge, there is a trial pending. I just want to make record the trial's vacated. Any protection order bond can be released from those cases, the usual procedural matters.
Yes, and that would take place given the dismissal being granted here.